Well, welcome everybody. I am so excited to be here today to talk about a really brand new statute from February. It's very complicated, the Extreme Risk Protection Act. I have with me two guests. Michael Nichols is a criminal defense attorney in East Lansing, and he brought along with him Deputy Chief Andrew Tobias, who's at the St. John's Police Department. And I'm excited for a couple different reasons. One, I've been to at least two seminars that have talked about ERPO, and they were great. So shout out, first of all, to Natalie Lane, who's a family law attorney who presented on it back in January. And then just last week, I was at the Family Law Institute, and judges Carla Testani from Wayne County and Tina Yost Johnson from Calhoun County also presented on it. All of it really good information, but I really wanted to bring a perspective to the family law attorneys that maybe you're not going to get from a judge or a family law attorney. So today we have with Mike, the criminal defense perspective, and with Deputy Chief Tobias, we have the officer's perspective. So first of all, thank you both so much for being here today.
Thank you.
So there is so much to talk about, and I really wanted to be about what your insights are. Both of you. I made slides. I really don't think we're going to get through all of them. The reason we have the slides is because there's just a lot of text that's really important to understand. So really, I want this to be more of a discussion about the statute, how it works, what maybe failings we see in it, what problems we anticipate, whether we're representing somebody who is trying to get one or who's trying to defend themselves as a respondent. Or a restrained individual from an ERPO. So let's just get right into it, unless you have any introductory comments you want to make.
Well, from my perspective, I need to first give a shout out and a thank you to my friend, John Schwartz, who's an attorney in Saginaw. I got hung up in court in Oscoda County for what I thought was going to be a very quick pretrial, and it turned out to be a little bit longer than that because it was a full courtroom and everybody was getting stuck with cash bonds and all that drama. And so anyway, thank you, John. When it comes to the slides, I'm a big believer in less is more when it comes to word count. But here we figured there's so much substance to this labyrinth of a statutory scheme that we just put a whole lot of copying and pasting from the statute into the slides so that you've got the meat of the statute right there, the statutes. But there will be one slide that's kind of a quick hitter that I'm going to go through when it comes to challenges. So that's my introductory comment. I also want to thank Deputy Chief Tobias for pulling his butt out of the woods and into the internet for joining us on the webinar.
Deputy Chief Tobias, do you have anything you want to say?
I am shocked to hear Mike say something about word count. I have seen his briefs.
You haven't dealt with appellate attorneys, Deputy Chief Tobias. And to answer a question from the audience, yes, we will be sharing the slide deck. Now, disclaimer, it does not include all the statute. There's just there's some sections that are just so long and have so much in them. So just, go look at the statute too, but this will be like a little helpful tool. So let's just get started with extreme risk protection orders. Who can request them? This is different than a PPO, right? Because it opens the door to, I think, more people having the standing to request an ERPO, special relationship like family member, law enforcement, and healthcare providers. Any comments about that?
Well, to my way of thinking, it's a lot like a PPO in some respects, but you do have to establish the special relationship before you even get your foot in the door. So don't just blow past that, because I think a lot of judges are going to be really careful. Well, at least many judges are going to be really careful and take a look at that.
Yeah, and it's the normal people you would think of as being a special relationship: parent, a child, sibling, grandparent, grandchild, aunt or uncle, or a first cousin. So I did want to point out a little fact that I found out last week at the Family Law Institute. So far this year, there have been 126 ERPOs across the state of Michigan. 80% of them have been filed by law enforcement. And I thought that was really interesting. I guess I don't know if that doesn't seem like, it just seemed really strange to me that there would be that many that were pursued by law enforcement. And Deputy Chief Tobias, I know your office has been lucky in that they haven't had to deal with these yet, but do you have any thoughts about why there would be so many law enforcement petitions?
So my suspicion is, without actually knowing the case by case analysis of each one, is that law enforcement typically is there in the heat of it when the crisis is actually occurring. And with this new process in place, it's a tool that we're going to exercise to see how it works. And if this is, we had some workarounds before the ERPOs were in place, and trying to sort out, is this the best process? But I'm not surprised to hear law enforcement is the leading petitioner on this stuff. And again, it's because we're usually called to these scenes where the crisis is occurring right then and there.
I mean, from a family law lawyer perspective, I think that's reassuring that the law enforcement are the ones that are tending to pursue it, because if you're in a relationship, so you, let's just say husband-wife relationship, and the wife is in fear, I think it, like, if the other person knows that she's the one that requested, I think it just escalates the situation potentially. She's trying to take away my guns, or her mother's trying to take away my guns. I think that just kind of even makes the situation a little bit even more tenuous for the people who are trying to protect.
Similar to like shouldering that responsibility with domestic violence laws. We don't necessarily need the victim to pursue the charges. We can pursue on behalf. So I would agree with your sentiment there.
Now, I wanted to move on to where they can be filed, and there's different, depending on who the respondent is, there's different standards, but I really wanted to hear what Mike had to say about if the respondent is an adult, the ERPO petition can be filed in any county in the state.
And of course, all of us think the same thing, right? Forum shopping. And that's a conversation that the deputy chief and I have had since, this legislation looked like it was going to be enacted about, this time a year ago. You're going to have, judges are people just like we are. They all have different leanings. And I think you'll probably see counties where there are judges who are more likely, and they'll have higher numbers of issuance, lower numbers of denials. And, for example, Clinton County, 0 so far. Ingham County, 8 so far.
And Wayne County, 67 out of the 126. So I kind of also wondered if somebody might choose to go to one county over the other, because especially if it's an attorney who's maybe helping somebody behind the scenes, if they know that a county has systems in place and that they're used to handling them, would that make a person more comfortable about pursuing, if it's a special relationship petition? Would it make them feel more comfortable pursuing it? Well, I'm not going to go to Hillsdale County. I'm going to go next door. I think they're sort of next door to Wayne County, because I know the judges in Wayne County, hypothetically, are much more familiar with these, and they know how to process them and analyze them. I mean, it's just one factor, I think. But it does worry me that you could hypothetically go a case from Ingham County, you could go up to Marquette and get it. I mean, like, that just seems like crazy to me. And maybe the judge wouldn't grant it. I don't know. There's no standard in there about how to analyze that from the judge's perspective.
Right. And that's a legit scenario, right? I could drive up to Marquette to go get an ERPO against my wife.
Right, because all the judges around here know you.
Right.
For good reasons, of course. All good reasons. All right. And I just wanted to highlight that the person doesn't have to own a firearm for somebody to get an ERPO request for them. So I think it's the idea that they could obtain access, or have, anybody has a potential to obtain access. You don't have to have proof or anything that they actually have a firearm. So there's so much to look at when the judge is required to look at when it's analyzing whether to grant ERPO. And so I don't know how much you wanted to go into these. Mike, I can skip ahead because there's so many different factors. If there's any that you want to spend a little bit more time talking about, I'm happy to do that. But the history or attempted use of physical force, whether or not it involved a firearm.
And I think that there are a couple of factors early in the statute that we would expect, and I think we all agree are probably appropriate and applicable, like history of mental health concerns,
Here we are, sub B.
serious mental illness or emotional disturbance. And it's not just subjective, you've got an objective definition in the mental health code. But then we've got some that to me are subjective and a little mercurial.
We're gonna go backwards, but this one, like go ahead, keep talking. I'm gonna move it to the right slide.
Well, I mean, I read this and I said, okay, Andy got drunk Saturday night, so now that's a factor I can consider.
Oh, there we go.
As a judge, any recent abuse of alcohol, it's sub H under subsection 1. Any recent abuse of alcohol. First of all, what's recent? And secondly, what's abuse? I mean, my first wife defined abuse of alcohol much differently than my second wife. Thank God, by the way. But that really, to me, gives pause. And I think there probably could be some more meat to the bone for some of these.
Well, Michael, for one example, previous unlawful possession. I mean,
Right.
When? Could it be 20 years ago?
Right. Exactly right.
And who's checking to confirm? Like, does somebody have to have charges that were rendered against them? I don't know, Deputy Chief Tobias, if somebody, I don't know, like how you analyze if as a law enforcement officer who's maybe potentially going to be bringing one, you're probably not going to be relying on something like that standard because you're going to be, like you said, in the heat of the situation, the domestic situation that you're making observations that are not, unless you have a history, the person, right? Because you've arrested them before. Any thoughts about that?
Yeah, I mean, we have a records database, obviously. And so, if we may not necessarily be right there in the heat of the moment, the call for service, we would certainly do our due diligence to look up a history, whether it be through our records, a criminal history check, or firearms license checks, things like that, to see what the history may entail. Do we have calls for service that involve, previous aggressiveness with firearms, so on and so forth.
I want to go back to one of the required things for judges to look at that we jumped over, the personal protection order. So people can get an ex parte personal protection order. It doesn't even say like whether or not it was rescinded. So like it could be rescinded, but you still can use that as an element in deciding whether to get an ERPO, is kind of how I'm reading it. Previously entered or existing.
It's not much more difficult for me to get a PPO than to drink this bottle of water.
There was another one I wanted to point out. There we go. Previous or pending juvenile delinquency petition.
Pending.
Right. So obviously we're talking about a juvenile, but at that point, the person would have to know, like, mom or dad knows that their child, 3 years ago had a petition, right? Like, how does a judge find all this stuff out? Items the court must look at. I just don't know, like, what access with our state system is everything connected? For some things they are.
Well, I would say if you're the petitioner, run the iChat, run the criminal history, FOIA the police reports. You may not have time for that, but
right.
You obviously are going to make a sworn statement, in your attachment to the scale form order. And that's certainly information that if you're seeking the ERPO, you want to make sure to include for the judge, because the judge, it says in the statute, must consider those factors. And there are like, what, 24 of them, Lisa? Is that how many we counted, or did we not count them?
There what?
How many factors are there? I thought there were something along the lines of 24. I mean,
Well, there's a lot when you consider there's some with subparts. And there's a question from the audience about what is a weapon. And I'm trying to find now, I have to go back and find out which section references a weapon. I think she meant firearm. I'm not seeing which. Probably this one, brandishing of deadly weapon. Oh yeah. So that's a very good question, because this whole statute's about firearms, right? And whether they can possess firearms, but there's a lot of things that could be a deadly weapon that's not a firearm. And my Deputy Chief Tobias, help me out here. Like there's knives, right? A bomb? I don't know. Did you say baseball bat?
Yeah.
I mean, a car could be a deadly weapon, but okay, well, I don't think that's what they mean, but brandishing of a deadly weapon. Does brandishing, by the use, does the legislature's use the term brandish mean that it must be a firearm, because those two words often are together?
well, there's a definition in the penal code, but of course, this does not cross-reference that.
Okay. Definition of weapon, you mean?
Correct.
Okay. And then if somebody has tried to get a weapon or a firearm rather, okay, let's talk about what standard has to be met to get this ERPO. Oops, there you go. It looks like just for a regular ERPO that's not ex parte, I'm guessing, well, I have questions. First, are most of them ex parte or not? I don't know. And then I had another, something else occurred to me that I was wondering about. Now I forgot what it was. We'll come back to that. But only need a preponderance of the evidence to take away somebody's guns, restrict them. And you have to show these two, I have two different things you have to show by a preponderance of the evidence. Now, oh, I know what my question was. How many of the ERPOs have been because that the petitioner believed that the respondent was going to injure themselves versus injuring somebody else? They're maybe going to commit suicide. Do you have any sense, any thoughts at all about that? Have you heard anything?
I have not.
Yeah.
Okay, so
No either.
preponderance of the evidence, it has to be something's going to happen within the near future, whatever that means. Does that mean one day? Does that mean a week? I don't know what it means.
Hour.
An hour, yeah. To intentionally or unintentionally, I'm struggling a little bit, like, well, they're unintentionally going to engage in an act or make significant threats. How do you do that unintentionally? To intentionally or unintentionally seriously physically injure himself, herself, or another individual by possessing a firearm.
Yeah. I mean, it's troubling.
I mean, I think of unintentional injuries from a firearm occurring like hunting accidents, right?
Right.
Or a gun that's not properly stored and a child has access to it. But that's not going to be the subject of an ERPO, right?
I would think, we have a scenario where somebody's a mental health crisis and maybe they're just simply firing their gun off in the air, as maybe that attention getting, process or whatever too. They're not necessarily intending to shoot at anyone in particular, but unintentionally the bullet,
Okay.
must come down.
All right, there you go. Thank you. That's why we have you here, Deputy Chief Tobias. All right. But if they're going to get an ex parte PPO, which means no notice, you have to additionally show some things by clear and convincing evidence. So obviously the immediate and irreparable injury, and that the fact that giving notice will precipitate an adverse action. And then there's some urgency to it. That has to be decided within a day.
Yeah. And so if you're the petitioner and you feel like you need one, you really gotta flesh out. I mean, treat this like, all the language that you've got to use if you want to get a TRO. You got to really flesh out. This is why it's really, really likely to happen quickly. And we cannot give notice to the other side, because if we do, something bad's going to happen. They might, go back in the woods and kill themselves, for example. Hate to be so blunt. And I know in talking to the Ingham County clerk, she said, they've got to be extreme. The language is extreme, and the judges are going to be cautious about issuing, especially on an ex parte basis. It's got to be a significant concern times 10, right? I mean, immediate and irreparable injury to the clear and convincing standard. Maybe the third highest standard in our judicial system.
We're getting some really good questions and comments on the chat, so I just want to draw them out because I'm not sure you two are able to look at the chat. One attorney asked about the constitutional challenge because of the Second Amendment fundamental right to bear arms. Is the preponderance standard going to be challenged, right? Is that kind of what you were thinking already? I'm sure, Mike.
Yeah, that's coming up on a slide.
Let me go. I'm going to skip this slide because we don't need to get into we're not going to have time to go through every single slide. Okay, so what happens once you get the ERPO? So from my reading of the statute, depending on whether the person's required to immediately surrender their guns or whether the police actually have to go in and seize them, because either one of those things could happen, right, Deputy Chief? If it's going to be immediate, you also get an anticipatory search warrant. And I wanted to talk about a little bit about that. Actually, I'm going to jump ahead for a minute so we can talk about this anticipatory search warrant. I had never heard of that phrase before. Have you, other than this statute?
Yeah, we used them working narcotics back years ago.
Okay.
So if we were able to conduct a controlled buy here, then that meant we could then, if this happened, then we could do this. If this happened, then the search warrant could be executed.
And if all that happened, I would bring a motion to strike that search warrant and exclude all that BS evidence from a trial against my client.
So Mike, you and I were talking about this anticipatory search warrant the other day, and remember, you're talking to a group of family law attorneys.
Right.
So we're not dealing with the criminal defense system very often, or never, as the case may be. So when somebody goes to get a search warrant, well, when the officer goes to get a search warrant, what do they have? Just a regular search warrant. What is the basis for getting that search warrant?
To get a search warrant, you have to establish probable cause that evidence of a crime will be found in the place to be searched, right? That's very basic language in almost every single case. If you read any state law case from anywhere in the union, federal cases, that's pretty much the standard. And, I know there are a lot of family law attorneys in our group today, but, read American history. Anticipatory search warrants were not supposed to be a thing. John Adams and Sam Adams, when they talked about what we want in a constitutional framework, nobody said, hey, let's have anticipatory search warrants as a thing. It's going to be rife for a challenge. And I'll talk more about that when we get to that slide, because you're going to have the right judge. But anticipatory search warrants, in my opinion, are per se unreasonable and unconstitutional.
So if an ERPO is issued, that can be one that can be done immediately, and the officer, they probably haven't been, I don't know if it's going to be ex parte, probably, but the officer is going to go in to make sure that the guns, either to seize the guns or to make sure they've been surrendered, right? And this is happening all very quickly.
I mean,
the officer.
I'll be frank. I mean, the term anticipatory search warrant is what sets me off. But if the legislature had simply used the term court order, because you've got the facts to support the conduct by law enforcement to go get the guns, that gives me less heartburn, I guess.
Yeah,
And
so let's look at the standard. The officer has to do an affidavit that there's probable cause that the firearms will be at a specific location. And the court has to believe that there's a fair probability that those items will be found there. So you have to have a specific location. Like, I guess I wanted to see what Deputy Chief Tobias had to say, like when would you think that would be appropriate to have this anticipatory search warrant?
You don't have to ask Deputy Chief Tobias that, because he's going to say a search warrant. What's that?
Okay, you're not him. Let him speak for himself.
It's weird.
I'm saving him from himself.
I just finished this morning, for a different case, but, I agree. You have to, there's a lot to the anticipatory search warrants and things. And our probable cause is probably going to be filled out with the petition for the ERPO as well. But, you start looking at where are we going to go looking for things. And more importantly, and especially in Michigan, we might be going to a local residence here, but then their cottage up north in Tawas, for example, who's executing that?
Right.
So you're the holding agency. Does that mean we now have to, fill up the cars and run northbound, or do I get a hold of the local law enforcement there? And do they have an obligation? Things like that.
And we're getting some more really good questions. Melissa asked about, with the anticipatory search warrant, is there an inventory of the gun safe done? So I think looking at the language of this is the court rule we were looking at about the probable cause. I think wouldn't the officer have to know that there is a gun safe, or have probable cause to believe there's a gun safe that would then have to be searched? Because you have to, how specific does a search warrant have to be? Does it just have to be that physical, that residence? Here's the address we're going to search, and you get to search the entire house? I don't know, maybe.
Typically within the search warrant, it's going to say the house, and then you probably would identify any sort of safes that would commonly store firearms, whether it be small, like a shoebox, or, a large vault type safe, or even a safe room. But yeah, and then there is the tabulation on the backside where you inventory everything that the police do take out of the house.
Which you would want to do for your own protection. That's like an inventory or impound. When law, I guess, got to remember, these are a lot of family law lawyers who may not know criminal law world, but when law enforcement, when they impound a car, like they pull somebody over, arrest them for drunk driving, impound the car, remember from law school, the inventory search exception to the warrant requirement. So it's there so that, in large part, law enforcement can protect themselves from claims by people, of theft or damage to the vehicle. And so you're inventorying what you found in the car and what you did with what you found in the car. For example, there was $500 cash in the center console, seized and put in the property of the accused, of the defendant, at the jail, right?
Exactly. It's going to protect law enforcement. That tabulation is going to be the inventory sheet. The inventory being the exception, but the tabulation attached to the search warrant and the affidavit.
I want to go back one slide, because there are two different ways of having these served. One was an immediate surrender, but that's a part of the statute that requires extra steps. But there's a presumption that the respondent will have 24 hours to surrender. So I think if there's I'm just trying to figure out how the statute works, but if there's really a imminent risk, then that's when immediate surrender would need to happen. The police officers are going in with their anticipatory search warrant to get the guns to prevent something horrible from happening. But the presumption, interesting that the presumption is that the person will get to surrender themselves, and they have 24 hours to do so.
And this is where my question would be for this. And if I believe that they are such a danger that I need to seek this ERPO, why on earth would I say, but go ahead and possess those firearms
For 24 hours.
and turn over too? That to me is the curious part of this. I don't know tactically that I would be comfortable saying, you got 24 hours to go make a decision on, are you going to arm up and have your last stand, or are you going to hurt yourself or others? I think if we're going to be dealing with these ERPOs, I think that person is in such a crisis scenario that I don't want them even for a second to possess those.
Yeah.
So,
And if you represent the petitioner, really, you need to put those allegations in your pleadings. And I would suggest, you draft hearing memorandum or petition memorandum that you attach to your form. And that's a legit concern, not just in rural parts of the state, like where I grew up, but where I live now, which is East Lansing. Those situations happen. The barricaded gunman making, as Deputy Chief Tobias put it, the last stand. And nobody wants to see somebody die.
so a comment from the audience from Melissa made me think of something. I'm going to bring up her comment in a second, but it ties in with what I learned last week at the Family Law Institute. So when the judges presented, they did their presentation on both PPOs and ERPOs, and it was a combined, topic. And the recommendation basically was like, if you're going to be getting a PPO, you should be getting, you don't do one or the other, you go get both of them at the same time if you think they're, and that may be more of a not as an emergency.
ERPO and a PPO at the same time?
Mm-hmm.
Okay.
So bringing it back to the audience, Melissa posted about getting the ERPO at the same time as a petition for a mental health commitment. Where did Mike go?
I'm here. I just needed to pick my nose. I'm here.
Okay. We'll use that sometime later. But yeah, like if a family member thinks that their loved one is in such an unstable situation that they need to have a mental health commitment, that actually it does make sense to, I can't speak specifically about PPOs and ERPOs at the same time. There was a rationale for that. And because I really I'm not the one that's in the trial court, like handling these situations. I'm reviewing the record on appeal, which is very different. But if you do have the mental health commitment petition that you're bringing to court, it kind of does make sense. If you know the person has guns and they already have a mental health issue, that logically they go together. And they would potentially be in, well, the mental health commission is that be in front of the probate judge, but the ERPO is going to be in front of the family division judge. Am I right? I think I'm right.
Why not, go PRT the person as well?
Do what?
Seek an order for a person requiring treatment under the mental health code. I mean, why?
Right.
Go
right.
trifecta, PPO, ERPO, and a PRT, or a order for treatment. It's the mental health code at like 330/2024, section 124. I'm thinking. This literally just came off the top of my head, so I'd have to.
Right. But I now I'm thinking about it. If you have to do one in front of a probate judge and another in front of a family division judge, some counties it will be the same person, right? We have Judge Garcia here in Ingham County. He is both, he sits as probate, but he's a family division judge, so he can handle both matters. But if you're in a county where they're not even the same, Wayne County, that's a good example. They're not even in the same building, right? Is there a way for you to let, like on the form, like I'm bringing this to you? Like, I don't know, like I think it gets complicated.
Wouldn't that be like your 2.113 requirement where you're saying there's a proceeding related to the same parties and or similar cause of action,
right?
Filed in the probate court in re so-and-so.
Right, but then you're not filing them both at the same time. Right, but they're not being filed at the same time.
Yeah.
So there could be some timing issues. So
I mean, you wouldn't, from a practical standpoint, you may not have a case number, but you can at least describe what you're doing.
So I'm going to jump ahead to this is what gets surrendered, right? If the person can, once the ERPO's issued, the restrained individual has to fill out a form and turn it in within 24 hours that they either surrendered the firearms or they had them seized. So even if they were seized, according to the way the statute reads, if your weapons are seized, does the officer fill out that form for them when they seize it? Or I'm just a little bit confused about how logistically how it works. Any thoughts about that?
It's just really, it's choppy. It's really
Yeah.
choppy.
Part of me thinks that, it's a great process to write out, but I think people who wrote it out weren't dealing with people in crisis at 2 a.m. and trying to convince somebody that otherwise is not happy with their predicament to say, hey, can you fill out this form for us? I just don't see that being, it would probably be law enforcement. And then similar to like a Miranda sheet where they're handcuffed and they can't necessarily sign it. But, thankfully now in 2024, we also have the body camera footage that can say, hey, we did, go through this document with them. They were unable or unwilling to fill this form out. So on their behalf, we did complete it. But I just don't think some of these processes were written in respect to, okay, when we're dealing with these, a lot of times it's going to be in the heat of that crisis.
Right. And I wanted to point out, like, even if the officers
And
go
you've
in
been there, right? You've been there when you were a cop.
When I was a street police, yes. In fact, one of my last major calls was a barricaded person in mental health crisis, unfortunately a veteran, and there were firearms involved. It was pre-ERPO, it was in 2023, but shots had been fired, and it was that 1 a.m, we're in crisis, things are escalating. Thankfully, no one was injured, no loss of life, and we were able to get the person the help that they needed through some veterans programs, and we were able to secure the firearms and then turn them over to family members.
I wanted to point out that even if the cops go in and seize the weapons pursuant to the ERPO, if that restrained individual holds a concealed pistol license, they still have an obligation within 24 hours to go turn in that license, that piece of paper, to the county clerk's office. And according to the statute, all of this if this all hasn't been done, it's supposed to be done within 24 hours, but within 5 days, bench warrants can start issuing. So that's just,
it's nice on paper. The CPL license is the size of a driver's license. This one might be one where it should be on law enforcement or the courts to say, by the way, when we issue this ERPO, we're going to do a check on CPLs. And if we have that, we'll put a notice that the CPL is no longer valid or it's suspended or whatever the case may be. And the matter flushes itself out.
So if somebody's going to go surrender their firearms, they don't need to wait for whatever the circumstances are. They're not being seized. They're just going to go surrender it themselves. They bring it to their local law enforcement agency. But there was this other provision in the statute that in addition to the local law enforcement agency, a court has discretion to allow the respondent, the restrained individual, to turn their guns into a trusted licensed firearm dealer, which I thought was really interesting. And now all the circuits have to come up with a list of who those people are, which I'd love to hear your thoughts about how that process might work, and why would that be better or worse than just like what would be the thought process in handing them over to the police versus to a gun dealer?
I mean, this harkens to what Judge Thomas Leo Brown once said, and those of you who practiced in front of Judge Brown in Ingham County, his famous phrase was, and he served in the legislature, this is why I think the legislature shouldn't make laws. I just think it's the dumbest provision, because for so many reasons, not the least of which is what I'll defer to Andy on, but what gun dealer is going to want to play nice with the red flag enforcers, first of all. Secondly, what qualifies a judge to be able to say, this licensed firearm dealer is trusted? By who? And for what reason? It's the only one in the, for example, 23rd Judicial Circuit.
Well, and you have the federal government, recognizes a degree of trust when they issue the FFL license to a gun dealer. But just like Mike said, I don't know any FFL dealer or gun store or whatever that really wants to participate with this, because it is considered that red flag law. And I just think that's bad for business. Obviously, in law enforcement, my goal would be, if I don't have to maintain these guns, then I don't have to create additional space in my evidence room, because part of the statute says the firearms have to be maintained as evidence, but separate from evidence. So that, when you have a smaller shop or smaller.
Right, is it because a crime hasn't actually been committed, right? This is to prevent a crime from happening, so it's different. It's
Right.
not really evidence, but yeah, I see it. Like it had, where are these going to be stored within the various local law enforcement agencies? Has everybody like come up with a plan? Like, okay, we have this locker in the event that we have an ERPO petition that comes across our desk, and now we know where to put them.
Sometimes you've got to just figure it out.
Yeah, I mean, and that's, I can speak for ours, as we have a separate locker in preparation for this, kind of an anticipatory locker, Mike. But yeah, I don't know a gun shop that would want to be on that list of, yes, we will hold your guns. I can tell you, I have a sister that runs a licensed gun shop, and my recommendation to her as her brother and as law enforcement was, please just don't participate with it. It sets you up for a number of issues that you just don't need to assume that liability.
A really valuable antique gun, for example, or just a really, really nice gun that, is worth a lot of money. Sometimes guns are worth a lot. And
yeah,
what happens if somebody says, I went to auction this and the offer was 10 grand. Now it's 6 grand. And that's because you guys, scuffed the bolt action while it was in your possession. And I'm suing you now.
There is it's my understanding that within the whole statute, there is kind of, we an immunity built into it where we're not liable for damage as long as we take reasonable care and caution to it. But, as a firearms owner, as a firearms collector myself, and from a family of firearms collectors, I would agree that even, reasonable care and caution could, result in damage, because I don't have, in our evidence room, we don't have necessarily a moisture control system in there that is robust enough that many gun safes do have. And so we do, run that concern, and we don't want to hurt anybody's property or damage anybody's property.
But you bring up an interesting point, because I don't even think we have a slide on this, but the ERPO lasts for a year and it can be extended. So we're talking about, at some point you could have quite an assembly of weapons that you're holding that really are evidence, but aren't really evidence, right? That just, you're the storage facility for them, basically.
And in communities throughout the state, there are, citizens who that is their hobby, that is their passion, and they have these extensive collections. And so now we're thinking of room and where we're going to put them. I guess worst case scenario, I'd rather see the police maintain and keep these, because what's also to stop somebody who is, say, they're trusted except for when their cousin gets the ERPO filed against them.
Mm-hmm.
And, I don't agree with the ERPO, fundamentally, or I don't agree that you're in crisis. So I'm on the trusted list. I'll give you your gun back once you get out of the hospital or whatever.
Mm-hmm. Mm-hmm.
I mean, I just assume say, let's just remove that part of it.
Right. But I think your point about them not, the the dealers not wanting to risk their federal license is probably going to be the driving force behind. But we
Yeah.
still have to, somebody has to come up with this list. Okay, so let's move on. There's going to be a hearing at some point. Like if the respondent requests a hearing, they have to request a hearing. There's actually going to be a hearing just like you'd have in any other case with the rules of evidence and whatnot. But let's move to the next slide about when that hearing's going to happen. So it has to happen quickly. Mike, I don't know, PPOs, do hearings happen when they're supposed to? Because I know a lot in family law cases, there's a lot of ex parte custody orders, and there's supposed to be things that are happening within a very short period of time, and 14 days turns into 14 months, right? So I think it might be different in the world of PPOs and ERPOs, but like, tell me what your insights are.
So I don't deal with PPOs a ton, although I've got one that's been in the news this past year, but it really mainly my experience with PPOs is limited to Ingham County, and the judges are really good about getting you in. They won't even brook adjournments if you want one. They'll start the hearing. So the answer is yes. And here the language is a little bit similar to PPO language in that you've got 14 days to get the parties into court. Although the difference with a PPO is if I'm the respondent, I get slapped with a PPO, I file a motion for a hearing to set it aside or modify it. The burden is with the petitioner at that hearing. And is that same language?
I'm going to go back one. If the court issues, the court shall, if requested, conduct a hearing.
I don't
Might be
remember.
another. Yeah, I don't remember either. There might be the next slide. Yeah, well, that's to rescind. So this is just for the initial hearing, because if it's, issued ex parte, there hasn't been a hearing. So this is we're talking about the initial hearing. And if it's,
It doesn't say got the burden that I recall. Maybe somebody else
right,
has read that, but I don't know that that's in there, which is problematic. I mean, in my
right.
opinion, the petitioner should probably have the burden.
Well, isn't it the preponderance of evidence standard that we talked about earlier that's probably the burden.
I mean, I think that will be a question that
Yeah.
a good lawyer can probably convince a judge, and then we can get an appellate opinion after it goes up, and then we'll get some law on it.
So I just wanted to point out that there's two different time periods, because if the person who is restrained is also required to carry a firearm for their job, Deputy Chief Tobias, like you, we have to have that hearing in 5 days, because obviously it affects their employment if they're not able to go to work with their gun, right?
Yeah, correct. And I don't know that, I mean, if that were to happen to, somebody on my team here, I mean, we're going to be in no rush to bring that person back with a gun. We're going to, for obvious reasons,
Right.
I get the need to have it within 5 days because it can affect their employee. I get all that, but should we find, an officer who is the subject of the respondent on an ERPO, I think we're going to really kind of slow things down and make sure that that person is truly getting the services and the help they need, and hopefully we can readjust if
Right.
needed.
You don't want to be that chief or deputy chief who's in the news for having brought back somebody who then goes out and does something really tragic.
Correct. Yeah. And yeah, absolutely. And the welfare of our team, we're going to put, ahead of a 5-day period or anything. Sure. Again, this is neat on paper, but we're going to slow down and take some things, and probably add some other layers to this, evaluation and treatment.
So once the ERPO is issued, the respondent can file a motion to rescind. And I just really wanted to highlight that they have to have a preponderance of the evidence. But I was trying to think of like, how do they prove that they no longer pose a risk to seriously injure themselves or others? How do you, as the respondent who's had your guns taken away, okay, preponderance standard, that's easier to meet, but how do you prove that you're no longer, do you have to have a medical examination? What do you think?
I would get a psychological evaluation and probably show that my client has, if medication needs to be prescribed and taken, or was prescribed but not taken, have the client do probably an affidavit that's very short, right? Because affidavits can be dangerous. And, a report from a medical professional, psychiatrist, psychologist, doctor, just like with a driver license scenario. But we've also, this kind of blends into the challenges slide. I don't know if you want to jump to that, or if maybe you had a thought on that, Lisa.
Oh, no, I could jump ahead. I have to find it. Where'd it
Jacob.
go? Oh, is it not showing up? There we go. How is that?
So the big one, if I have a feeling that there's a judge out there who is ready, willing, and able to declare this an unconstitutional series of statutes, but you got to know your judge. I've been blessed to have some really good rulings over 25 years. And it's every time I look back and say, I had a feeling that judge was going to do that or do this. And you just got to know the judge and be ready to really brief out those arguments, not just the Second Amendment, but if you really get your arms around this series, and I say series because it's not just under the ERPO statute. They also added and amended some things in other sections of the revised Judicature Act, as well as the court rule. I mean, this is a very broad law, and so there's that argument, and be prepared to make not just the Second Amendment argument with the many people are aware of the Supreme Court opinion from a couple of years ago in Bruin, Bruen, which, God bless you if you can read it and understand it. It is a very complex ruling.
We don't remember that one. Can you tell us what you're talking about?
Sure. Bruin was a SCOTUS opinion that said, if government wants to regulate gun ownership and access to guns, you have to show a corollary to a regulatory objective. I'm oversimplifying it and maybe screwing it up, so grain of salt here. But it's got to be consistent with what the founders would have wanted when they enacted the Second Amendment and allowed gun regulations back in the day. And there's a very famous podcast, well, maybe not so famous, where Malcolm Gladwell talked about the history of Sir John Knight and gun regulations in colonial America. So without getting too far afield, just be prepared to talk about not just Second Amendment, but ambiguity, right? So many things that are made bad, so much conduct that's made bad by this statute. And also the breadth of the order. We talked about that. If there's an order that says he's got to divest himself of his guns within 24 hours, well, how is that defined? As Deputy Chief Tobias put it, do I have to go up to their lake house and, maybe they've got a third property where they've got a bedroom in their parents' home, then I've got to go get all those guns too. And then is this really an extreme situation? And I think a lot of judges, if I'm a judge, I'm going to wrestle with that. Okay, this person is, maybe having a bad day, maybe said some stupid things, but is this a situation where if I don't act, they're going to take their own life or take the life of someone else, someone close to them? And really, I would want to know, is that person identifiable? The kids, the wife, brother, sister, boss. Those are my thoughts on that. I didn't really do a deep dive into the research or the thought. A lot of this is, the product of 3 or 4 beers with Deputy Chief Tobias and just talking about how far our government is going right now.
Yeah, thank you. So, we do expect challenges. The statute's pretty confusing. I wanted to go back because we jumped over some slides. And I just wanted to talk I was trying to go out when
Good
you were
point,
talking,
yeah.
Michael, I was trying to look at like what is really the standard. I was looking at the standard again of how to get one in the first place. Like what is the extreme situation that we're facing? And it's really that there's some sort of, like mental health issue and the person that they don't have to have guns, but there's a risk that they could get guns because of things that maybe have happened in the past.
Yeah, great point. I'm so glad you thought about that. Thank you for bringing us back to 3.721, subsection H. It is contempt of court if you do not comply, if you are the subject of an ERPO. And remember, first of all, you have to show that it was willful. And if you're incapacitated by mental illness, is that willful, or is that you're just you need to be medicated or take your medication?
And how do you decide whether it's criminal contempt or civil contempt?
It's got to be shown by clear and convincing evidence.
Well,
there are new cases out in the last 2 years from our appellate courts about how courts exercise the contempt power. But indirect contempt basically gives you the right to a trial, not necessarily a jury trial, but a trial where the other side, somebody's got to prosecute it. I was just asked by a court to prosecute contempt of court, and you've got to show that it was willful, and you've got to show clearly, right? It's clear and convincing or clearly shown. Here, the language in the court rule actually says the prosecuting attorney has the burden of proving the respondent's guilt of criminal contempt beyond a reasonable doubt. I can assure you that there are many prosecuting attorneys' offices around the state that hate that, because it's one more thing that they've got to do with no more money to do it. The legislature did not budget additional funds for prosecutors' offices to prosecute these cases.
I'm seeing a lot of helpful information in the chat. I think I can save the chat so I can pull some of these comments out when I circulate our takeaways. One question was about if the guns are out of state.
Oh yeah.
I mean, there's an access issue perhaps that they won't have access, but if they're in Indiana right across the border, I mean, I don't know. Like, are you getting a list of where the person, Deputy Chief Tobias, are they saying this is where I think the guns are? And then you have to go associate with various local agencies wherever those, like if they're in 3 different places. I mean, I don't know.
I think it comes down to, yeah, I mean, obviously you would try to debrief with family members or anybody who has intimate knowledge of this person's, location, whatever, I don't know. And that's the hard part is, and where's the responsibility at? Because if we are the agency where the ERPO was basically, entrusted, is it our responsibility then to drive to another town or out of state? I think that's a great question. I have a close friend of mine who actually owns hunting property in Iowa, and but he's a Michigan resident, Michigan voter. My in-laws, live in Michigan 7 months a year, and then they travel down to Florida. Whose responsibility is that? And will those jurisdictions outside of the state recognize the predicament that we're in? I don't know.
If you're the respondent, you'd have to domesticate your order in the other state under the uniform. Yeah. What is it? Uniform Domestic Orders Act. But Liisa Schmidt, great site here. I didn't know about this case. U.S.
I'll be including in the material so that you'll be able to take a peek at that. The U.S. versus Rahimi about domestic violence.
Yeah, I missed that case. That's awesome. Thank you.
We're out of time, but I just really quickly wanted to point out 2 slides because there's penalties for violations, and or failing to comply, and so that's in the statute. But there's also penalties if you have false statements seeking a petition. So I think that's important, because they're like in family law situations, sometimes things are sometimes exaggerated or misunderstood. I think it really, I don't know if this could be abused, of course, but I think it maybe gives people pause. Like, you should not be seeking this unless this is a serious situation. It's kind of how I view it. Well, with that, I think we're done. I can't tell you how much I appreciate both of your spending your time with us this afternoon and educating us on a little bit of the area of law that maybe we're not quite as familiar with, and hopefully we can do a better job representing our clients because of it. And
Thank
hopefully
you.
you don't
Thanks
have
for
any
having us.
ERPOs come across your desk.
All right. Thanks, everybody. Have a great day. Happy
All
Thanksgiving.
right.
Thank you for having me.
Thank you. Thank you. Okay, bye-bye.